Be back in a second.
Sure.
Hazel, I don't see the slide. Will it be taken off?
Yes, Prof. You can start.
Can I start? Thanks. Good evening, ladies and gentlemen, friends and colleagues. I'm Professor Warren Friedman, and I'm the Acting Dean and Head of the School of Law at the University of KwaZulu-Natal. It's my honor and privilege to welcome you to this evening's webinar on the current and devastating war in the Middle East, entitled South Africa, International Law, and Palestine. I'm very pleased to see that so many of you have joined us online tonight. I want to extend a special welcome to our three panelists, Dr. Navi Pillay, Professor John Dugard, and Professor Max du Plessis, SC. As I'm sure you are aware, all three panelists are leading experts in the field of international law, and especially international criminal law, and have held positions on or appeared before almost every major international legal body and court, including the International Court of Justice. Apart from being leading experts in international law, I'm proud to say that all three panelists have a long association with the School of Law. Dr. Navi Pillay graduated from the then University of Natal before going into practice and eventually becoming the United Nations High Commissioner for Human Rights. Professor John Dugard began his illustrious teaching career at this institution, and so too did Professor Max du Plessis before going into full-time practice. I'm also proud to say that all three panelists have received doctorates or honorary doctorates from the University of KwaZulu-Natal, and we hope have very fond memories of the time they spent in the School of Law. We are very grateful that they have agreed to share their expertise and time with us tonight. Finally, I want to take this opportunity to congratulate my colleagues in the Navi Pillay Research Group for organizing tonight's webinar, and especially Dr. Janine Hicks and Mr. Chris Geerwins. It promises to be a stimulating and thought-provoking discussion on a very important and topical issue. I'm sure that you are looking forward to hearing what our panelists have to say and to engaging with them as much as I am. Thank you and enjoy the webinar.
Thanks, Prof. Friedman, and good evening, friends and colleagues. My name is Janine Hicks. I'm a lecturer at the School of Law, and I'm associated with the Navi Pillay Research Group, which is our host for this evening's webinar. So just to tell you a bit about what is the NPRG, the Navi Pillay Research Group. We established this research group at our School of Law in Dr. Pillay's name to honor her legacy and honor her agency, but also to serve as a platform for critical research and policy advocacy in the social justice sector. We really believe that academics and our higher education institutions and our university, UKZN in particular, should be active and engaged in the social justice space and not silent on the persistent injustices and rights violations that we see in our country and in our world. And in this regard, we really honored Dr. Pillay to have you on board our research group, not only as a patron, but also a colleague to inspire and challenge us in this regard. So the kinds of issues that we engage with as the Navi Pillay group include those that are on our platform at the moment are accountability for apartheid-era atrocities. We're calling for their prosecution in terms of international criminal law. We're engaging on issues pertaining to land reform and traditional leadership. We're also picking up on and engaging on persistent forms of discrimination and human rights violations, particularly those impacting on marginalized categories of people, such as abahlali basemjondolo, shack dwellers, homeless people, children, and people with disabilities. But it's through our interface on international criminal law matters that is spearheaded by Dr. Pillay and my colleague in the School of Law and our research group, Christopher Geerwins, who's going to be facilitating our webinar this evening. Through their work and their prominence in this sector, we have convened this evening's webinar. So many South Africans would be well aware that our DIRCO Minister, Naledi Pandor, has strongly condemned Israel's actions in the war on Palestine. She has cited these as a violation of international law, including the UN Charter, the Geneva Convention, and its protocols. She's also stated clearly that in its attacks on innocent civilians and the kidnapping of innocent civilians, Hamas has also violated international law. But she has noted clearly that the illegal occupation of Palestine by Israel for several decades has created a particular context of bitter hatred and increased violence. She's also stated that the targeting of civilians, the destruction of civilian infrastructure, and the murder of children, women, and aged by Israel constitutes war crimes in terms of international criminal law. Accordingly, South Africa has called upon the International Criminal Court, the ICC, to issue a warrant of arrest for Israeli Prime Minister Benjamin Netanyahu and members of his cabinet on the charges of war crimes, crimes against humanity, and genocide. At the NPRG, the Navi Pillay Research Group, we felt it was important to create a platform for these international law, criminal law experts you see before you to clarify for us precisely what are the obligations in international law, what is at stake in what is taking place in the Middle East right now. I think it's also pertinent to point out that this webinar is strategically convened. Yesterday was the 29th of November. We observed the UN declared International Day of Solidarity with the Palestinian people. Today, the 30th of November, is the 50th anniversary of the Apartheid Convention, which by all measures South Africa is in the process of ratifying. And in February 2024, the International Court of Justice, the ICJ, will convene public hearings on the United Nations General Assembly's referral on the legal consequences arising from Israel's policies and practices in the occupied Palestinian territory, including East Jerusalem, over which commission our very own Dr. Pillay presided. South Africa is likely to make a submission at this hearing, And so towards the end of January, our research group is set to convene a follow-up webinar together with stakeholders from that UN Commission to surface critical issues in this regard. And we'll be sure to invite you. So to lay the groundwork for these deliberations, we are delighted to have this panel of experts available to join us and provide their considered input. I'm now going to hand over to Christopher Gevers, who will introduce our speakers, talk to the flow of our evening's webinar and facilitate our discussion. Thank you for joining us in this very important conversation.
Thank you, Dr. Hicks, and thank you first and foremost to our audience and to Dr. Pillay and Professor Dugard and Professor Duplessis for being with us today in what is undoubtedly a very busy time for anyone who does anything related to international law. So I don't want to take too much time with introductions. What I did want to say is just speak a little bit about the context within which this webinar is taking place, both historically and in terms of the present. So the present context obviously is in relation to the ongoing conflict in Gaza, but it's also, as Dr. Hicks mentioned, the 50th anniversary, I should say, of the Apartheid Convention. And I think it's important for us to hold in our minds the context more broadly and the relevance of the Apartheid Convention to what's happening at the moment in Palestine. And I'm hoping our speakers will say something about that. But it's also the 60th anniversary of an address by a very young Miriam Makeba to the United Nations Special Committee Against Apartheid in the UN in 1963, where she called out the treatment then of South Africans, which she referred to as an open-air prison, which is something we've heard many times in relation to Gaza. And it's the spirit of Miriam Makeba I want to invoke today, the courage that it took for a young person to speak those words in 1963 before, and on the poster behind you, behind me, in fact, on the poster you would have seen, is an image of a very young Miriam Makeba making those very, very prominent and very, very powerful statements. And I want to suggest both that we should be inspired by her and also honor the various women who have led South Africa's international relations. And I want to honor Dr. Pillay as one of those women, Dr. Pandor as well, who at present is really carrying the torch in respect of standing up in very difficult times for what's right. So I really want to congratulate and thank all of you for being here. And before I hand over to Dr. Pillay, just to say, I don't think any of our speakers need introduction, but for those who are keeping track, so Dr. Pillay was a graduate of this law school. She went on to Harvard Law School. She was, in fact, I think, the first South African to get a doctorate from Harvard. She was a judge of the High Court in South Africa. She was a judge of the International Criminal Tribunal in Rwanda. I think she was a judge of the ICC. She went on to become a High Commissioner for Human Rights, and now she's sitting on a commission of inquiry into the situation in Palestine. So I'll say this again in 3 more times, but we really could not find better hands to have this conversation. And I really welcome Dr. Pillay's remarks. Thank you, Dr. Pillay.
Good evening, everyone. It's morning for me. I am currently, just for a couple of weeks, based in Roosevelt House. This was the home of President Roosevelt and Eleanor Roosevelt in East 65th Street. I'm spending some time with the students here, and obviously what's happening in Israel and Gaza now is taking up the main area of interest of all students. They really want to know what's happening. And I want to say how much I appreciate my alma mater, UKZN, taking a lead in arranging this webinar. I, of course, will be speaking not as a South African, but as an independent commissioner of the United Nations. Before I begin, let me also pay tribute to who contributed to get me where I am today, and that is Professor John Dugard. He may not remember, but he was very, very young, and he was my first lecturer at Natal University in law. So I've not let you down, John. So my task today is just to give you an account of this commission of inquiry. It's got a long name. It's the Independent International Commission of Inquiry on the Occupied Palestinian Territory, including East Jerusalem and Israel. And so there are many things new about this commission. There are 3 commissioners serving on this. I chair it. I'm from South Africa, and Chris Sidoti from Australia, and Milun Kotari from India. So the three of us, and we've already prepared 4 reports. We're required to present a report to the Human Rights Council in Geneva every June and to the United Nations General Assembly in October of each year. Now, when this resolution was adopted in the Human Rights Council, there were a significant number of states, including the United States. No, the United States was not a member at that point. Almost 22 states, mainly from Europe, voted against the establishment of this commission. So I was there, we delivered our report, and in the interactive dialogue, some of these states, including the United States, explained why they opposed the establishment of this commission. They said it has no end date, so it's virtually permanent. All other commissions focus on particular issues or episodes, and they have a cutoff date, 1 year, 2 year, or something. So this is obviously going to go on until the occupation ends. Those who voted against the commission on that ground, that it doesn't have an end date, seem to forget that there is no end date to the occupation, which they tend to support. The other reason is the wide territorial jurisdiction, that we now have the power to examine the situation inside Israel, the West Bank, Palestine, Gaza, and spill over into neighboring countries. So it is a wide mandate. We are asked to identify the root causes of the conflict, offer recommendations, and identify key perpetrators of crimes, and gather evidence, and cooperate with judicial institutions. And here we have in mind the International Criminal Court, the only one we have so far for international prosecution of these very serious crimes. And we've already established contact with the prosecutor of the International Criminal Court to share the information that we are gathering. And we also are mandated to address ongoing events. So past, present, the historical, present, current, and making recommendations. It is a huge mandate. So when we delivered our report in October last year before the UN General Assembly, we recommended, having set out all the facts on the ground, having set out international law as we saw it, we recommended to the members of the General Assembly that they refer the issue to the International Court of Justice on 2 issues. One, is the occupation lawful? It's now 65 years of occupation. We say in our report that in our view, it's become permanent. Israel has no intention to end the occupation. And international law never envisaged permanent occupation. Therefore, as we see it, it is now unlawful. And secondly, we suggested that the court be asked to set out what are the responsibilities of states towards this unlawful endeavor. Now, that's very important because many people have told us, we can see the facts ourselves, that Israel has managed to perpetuate this occupation this long, mainly because of the military, political, and moral support it receives from various states, in particular the United States. So the second prong of the opinion we are seeking, I think, is important. And to my immense pleasure, the General Assembly, by 87 votes, did adopt that resolution. The issue is now before the International Court of Justice. And I've heard from the legal counsel at the United Nations that he himself, preparing the relevant documents for that court case, finds this is the largest collection of document and information that the legal office has forwarded to the International Court of Justice. I think he said 4,000 documents at that time. And almost 58 submissions, briefs have been made to the court by various states and other agencies, institutions that have been permitted the right to submit these briefs. And I am pleased because this kind of opinion has never been sought before. The only precedent is that in 2004, the International Court of Justice ruled on the what we call the wall case. In that situation, they found that the wall that Israel has built encroached onto Palestinian land and was unlawful. But in that case, although they didn't tackle the issue of the lawfulness of the occupation, they said that the building of the wall itself is like Israel putting footsteps on the ground to make the occupation permanent. So it's historic that we made these submissions, that they were accepted. It's now before the court. It received very strong objections, the resolution before the General Assembly, and including our report. In fact, when we delivered our report in October last year, we suffered a great deal of abuse, mainly from the ambassador of Israel and some of their lobbyists, and I objected to this. I said that here we are, independent commissioners, we'll not be receiving any payment for doing this job, which should establish our independence. We gain nothing by it. We are mandated to come and deliver reports before the General Assembly. So it's incumbent on the United Nations to ensure that we have a safe place to deliver these reports. And that protest that I addressed publicly seemed to have been heeded, because when we just completed our report this year, on October 24th, before the General Assembly, at least we were given a respectable audience there, instead of pranks and interruptions and labeling us anti-Semites and so on. So let me say that in this time we were there to deliver our report on the 24th of October, a report that in terms of UN rules we had to complete by August. But what happens, the October 7th attack by Hamas happens, and I found that I had to begin by really referring to the eruption of violence in Israel and Palestine since October 7th. I said it's very shocking and concerning, and that thousands of civilians have been killed or injured on both sides. The figure now of Palestinians killed in Gaza is extremely shocking, 15,000 almost, and the most number of UN humanitarian workers have been killed in this struggle. The most number of journalists have been killed in these attacks following the October 7th attacks. So we immediately issued a statement unequivocally condemning the Hamas attack and the ongoing US military attacks that resulted in so many thousands of deaths. Now, our report was completed before this latest upsurge in violence. However, I said that the findings are tragically relevant because our report examines the use of force by Israel and the de facto authorities in Gaza, one dimension of Israel's unlawful occupation of Palestinian territory, which has carried devastating implications for Palestine. The detrimental impact of occupation on the lives of Israelis is also clearly evident today. So that was the basis of our report. The report finds that Israel's increasingly militarized law enforcement operations in the West Bank, including East Jerusalem, and repeated attacks on Gaza consistently violate international human rights law and international humanitarian law. These acts, we said, are intrinsically linked to Israel's goals of maintaining the unlawful occupation, weakening Palestinian opposition and their right to self-determination, fragmenting Palestinian political, economic, and social cohesion, and ultimately denying Palestinian self-determination and preventing the establishment of a free Palestinian state. We found unequivocally that the indiscriminate firing of projectiles by armed groups in Gaza towards Israeli towns and cities constitutes a war crime. The prolonged Israeli occupation of Palestinian territory, we said, has led to widespread protests among Palestinians who are asserting their rights to self-determination. We concluded that the force used against Palestinian demonstrators as a crowd control measure is systematically excessive and consistently exceeds what is strictly necessary and proportionate. And our findings further reveal that Israeli security forces commonly use live ammunition to suppress protests in the West Bank, including East Jerusalem, harming unarmed demonstrators and other persons who did not pose an imminent threat to life. So, of course, it's an extensive report, but it tells us the background, the context, so that, you know, one should not portray this as something that started on October 7th. So the Secretary General was quite right to say that didn't happen in a vacuum. There is a context of protest and suffering towards this. Now, I know that John and Max will address the law, but we had to do this very carefully in these reports as well. We, as I said, we found that the occupation is now unlawful under international law owing to its permanence and owing to actions undertaken by Israel to annex parts of the land, de facto and de jure. And so we focused our report on the use of force in the occupied Palestinian territory and in Israel, because our mandate allows us to cover this. And we analyzed the human rights and legal consequences of force used, and we identified the root causes of recurring violence and the protracted conflict. We based our report on many interviews that we conducted with primary and secondary sources, right up to 31st July 2023, open source research, meeting with stakeholders, public hearings, and submissions received following a call issued on 2nd November 2022. Of course, we consistently and repeatedly asked for Israel, and we copied the United States, to be allowed access into Israel. And I have made stronger calls now because we're the only UN institution that has a mandate to conduct investigations. You will notice that no new commission has been set up by the Human Rights Council to investigate what is going on now and since October 7th. That's because we have a mandate. So we basically stopped our planned work and began investigations. By 6 a.m. on October 7th, our team had already started collecting evidence from open sources. They tell me that of the materials they managed to collect and safeguard, 45% of it has already disappeared from those sites. We don't know who has removed them, but at least we have them in our custody, and we will be sharing that information with the prosecutor. We haven't had an opportunity to analyze the evidence. And just today, we sent out a call for submissions from anyone in relation to these October and ongoing incidents, killings, injuries, sexual violence, and all these allegations that we are hearing about. We've immediately commenced our investigation of this. So that is a setback to our planned work. We intended to look at the right of return of Palestinians, for instance. We intended to examine the so-called self-defense that Israel is claiming. It is exercising self-defense against terrorism. this will be addressed, I'm sure, by John Dugard, but we noted that Israel has invoked Article 51 of the Charter of the United Nations, citing self-defense against an armed attack to justify its military operations, which has so far resulted in 15,000 killings. Now, in 2004, the International Court of Justice held that Israel is unable to rely on Article 51 in relation to an attack emanating from the occupied Palestinian territory, given that the whole of the territory is under its effective control. The Commission then reiterated the important distinction between jus ad bellum and jus in bello, and notes that Israel is obliged to follow international humanitarian law in all its military operations. And we also distinguish, for instance, on the West Bank, inside Israel, that what Israel is doing there is clearly law enforcement activity, and there they are controlled by international human rights law. So both these sets of laws apply. And I'm very wary of exceeding time. I'm going to stop there, and I look forward to the questions. Thank you.
Thank you, Dr. Pillay. So thank you for so powerfully setting out the context and reminding us precisely how long this has been going on and the various different institutions of the UN that have been engaged on this question for a number of years. So one good indication of that is that I think Professor Dugard was appointed to the commission in 2001 that was investigating this very same conflict. So the conflict has involved various mechanisms of the United Nations, and we're going to hear a little bit about another body, the International Court of Justice, in a moment. Just to introduce Professor Dugard, so aside from being the esteemed professor who taught Dr. Navi Pillay, Professor Dugard studied at Stellenbosch and then went on to Cambridge University. He was a professor and I think dean of the law school at Wits. He's had appointments at Leiden University and Cambridge as well. He's been a member of the International Law Commission. He's been the head of an inquiry into the situation in Palestine. I think at present he's an extraordinary professor at Wits University as well. So thank you so much, Professor Dugard, for being with us. Sorry, Professor Dugard, I think you're on mute.
Sorry, you
You're
can hear
audible.
me now.
Go ahead.
Thank you very much for inviting me to participate in this evening's discussions. Let me say at the outset that I well remember Navi Pillay as a student. In those days, the law school of the University of Natal was situated in city buildings next to a large parking lot. And Navi will agree with me that the conditions at that stage were not really conducive to legal study, but nevertheless, we managed to do some good. And I think the result is before you tonight in the form of Navi Pillay. I'm going to be talking about the advisory opinion on the legality of Israel's occupation tonight. To begin with a few words about advisory opinions, the International Court of Justice in most cases deals with what are described as contentious cases, that is, disputes between states. But the Charter of the United Nations does empower the General Assembly and other bodies to ask the International Court of Justice for an advisory opinion on matters that are of concern to its work. And in so doing, the court has been asked to give an advisory opinion on the legal consequences of the occupation. It's important to stress at the outset that advisory opinions are, as they are described, advisory. They are not legally binding upon states, but nevertheless they do carry tremendous political influence. I think one needs to recall the 1971 advisory opinion on Southwest Africa, Namibia, which ultimately resulted in the independence of Namibia, but it did take almost 20 years to achieve that goal. At the end of 2022, the General Assembly of the United Nations adopted Resolution 77/247, in which, in essence, it asked the International Court of Justice for an advisory opinion on the question of whether Israel's occupation of the Palestinian territory, which has been in force since 1967, 56 years, had been rendered illegal as a result of a number of factors. First of all, the denial of self-determination. Secondly, the prolonged nature of the occupation. Thirdly, the annexation of territory, and that would include the establishment of a settlement empire in the West Bank, and finally, the adoption of discriminatory legislation and measures. The court has been asked to decide whether these violations of international law and international humanitarian law affect the status of the occupied Palestinian territory, and if so, what the consequences are for both states and the United Nations. A word or two about the procedures. The first step in the process is the submission of written statements, and some 56 or more states have submitted written statements in which they set out their views on the subject. The majority of the states have adopted the position of Palestine that the occupation is illegal because of the violation of these basic principles of international law. However, a number of states, including the United States and the United Kingdom, predictably, have objected on technical grounds to the giving of an advisory opinion. The next step is the second round submission of statements, and that has also taken place. The statements were submitted on the 25th of October. And on the 19th of February, the International Court of Justice will commence its hearings, its oral hearings on the questions before it. Let me say a word or two about the submissions of states. The submissions are confidential, so I'm not able to deal with them in detail. In the event time does not permit that. The states that have objected to the giving of advisory opinions, such as the United States and the United Kingdom and Canada, that is the states which have succeeded in disposing of their indigenous populations in different ways, have generally objected to the giving of an advisory opinion on technical grounds, such as the court has no jurisdiction, or that this is a political question that the court should not hear, or that Palestine is in effect bringing a contentious case before the court by way of an advisory opinion, or that negotiations are the course to be followed in resolving the problem. Of course, they failed to mention that, in fact, negotiations have not been taking place for some time, as the Israeli government has discontinued negotiations with the Palestinian government. Other states have made submissions dealing with the most important principles affecting the occupation of Palestine. First of all, the prolonged nature of the occupation. It's now in its 56th year. No other occupation has continued for such a long period of time. Generally, a military occupation is a temporary affair of several years, which prevails until states enter into a peace treaty to resolve their differences. But in the case of Palestine, it's now been going on for 56 years. Second issue is the denial of self-determination, which is fairly obvious. Thirdly, there's the annexation, the de jure annexation of East Jerusalem and the de facto annexation of the West Bank, because Israel has established a colonial empire in the West Bank by settling over 700,000 settlers in the West Bank and in East Jerusalem. So there is de facto annexation in that case. And then, of course, there's the problem of discriminatory legislation and related measures. And of course, this has enabled parties to produce evidence about a whole range of violations of human rights, the collective punishment of Gaza, the siege and blockade of Gaza, demolition of homes, administrative detention, torture, assassination of Palestinian leaders, and the collateral damage follows, the indiscriminate killing of civilians, the seizure of land for settlements, and of course, under the rubric of discriminatory legislation, apartheid. So the question of apartheid will be before the International Court of Justice. As to the evidence, the court will rely largely on reports and investigations conducted by the bodies established by the United Nations over many years, and they do provide strong evidence to support the violation of these principles of international law, international humanitarian law. That in brief is the situation at present. As I've said, the hearings will commence on the 19th of February. The final question I wish to raise briefly is, what is the impact of the present crisis on the advisory opinion? The second round of submissions closed on the 25th of October, so that meant that states didn't really have much opportunity to comment on the present crisis, the war in Gaza. They said so in a very cursory manner. But there's no doubt that the present conflict will affect or will come before the International Court. It will be invoked by those who argue that the occupation is unlawful to confirm the evidence before the court that Israel's violation of, or Israel's occupation of the Palestinian territory is discriminatory, repressive, and brutal. I think the present attack on Gaza has indicated the brutality of the Israeli regime, and no doubt this will be presented before the court. On the other hand, I suspect that the usual suspects opposed to giving an opinion who support Israel will argue that the present crisis has rendered the whole situation very uncertain and fluid, and that the court should resist giving an advisory opinion on this subject at this time. The court does have a discretion to refuse to give an advisory opinion, although it has never exercised this discrimination. I suppose we all like to think about what the likely outcome of the decision or the advisory opinion will be. I don't wish to predict the outcome. And suffice it to say that if the court does find that the occupation is illegal, one must bear in mind that it is advisory, and I have
So I think we lost Professor Dugard just as he was about to tell us who was going to win the case. And that's possibly why. Let's perhaps give him a couple of minutes. Hi, Professor Dugard. You're back, you're muted.
Yes, I think I've almost completed my task, and that is simply to say that I can't predict what the impact of the crisis will be on the advisory opinion. I can't predict what the outcome will be, but nevertheless, if the court does give an opinion that the occupation is unlawful, this will have serious political implications, and I like to think it will guide the future and result in the dismantling of the occupation and hopefully the independence of the state of Palestine. Thank you.
Thank you, Professor Dugard, again for setting out the context, and particularly the International Court of Justice, which we'll come back to. Now, by way of disclosure, I think I should say that, Navi, if you were taught by Professor Dugard, I was taught by Professor du Plessis. I'm not sure what that says about either my potential as a student or Professor du Plessis' capacity as a lecturer, but there it is. In addition to teaching me, Professor du Plessis studied or taught at UKZN, studied at Cambridge University, did his PhD at UKZN, and went into practice. And I think I can say fairly confidently that there's not a single case, as long as Max has been in practice involving international law, that Max hasn't been involved in some way. We won't say whether he won or lost the cases, but he was there. And so he's very well placed to speak about this question. And in particular, I wanted to ask Max to speak a bit about the International Criminal Court, which is in a sense the third prong of the institutions that are involved or engaged at present in the question of Palestine. And in particular, Max, I wanted to probe you. So Professor Dugard mentioned that jurisdiction is a question, perhaps when it comes to the ICJ, although I think that argument is likely to fail. Jurisdiction is undoubtedly engaged in the context of the ICC and has been for a very long time. So I'm going to put a sort of pointed question to you, Max, to speak a little bit about how the ICC has jurisdiction, and in particular, why not even since October 7th, but perhaps since 2020 or 2015, or as long as the court has had jurisdiction, we've seen so little action from the ICC on this question.
Thank you, Chris, and thank you for that introduction. Let me just say that John didn't teach me way back when at the old university buildings in the city. I'm a bit younger than that, but I can proudly say, to try and draw all of the links together, that John was the supervisor for my PhD. So we've all in some or other way played a role in others' lives. Can I say that I've been asked by Chris to speak on the potential for the International Criminal Court and other domestic avenues for prosecution. And he's also put the pointed question to me around what has happened or not happened before the ICC. And I'm going to do the best I can, recalling the important role that South Africa might or is already playing, and reflecting, as I think somebody earlier said, that it's the 50th anniversary of the Apartheid Convention today. And so I want to insist on that relevance and indeed the usefulness of the framing of the conflict a bit more broadly. And I'm going to try and do so through 3 topics. The first one perhaps is to immediately tackle what Chris has put to me, and that's to talk about the problem of double standards in international criminal justice. That leads me to the second topic, and that's because of the problem of double standards, there's the critical importance for South Africa of staying an objective and even-handed course in response to the conflict. And then third and finally, I'm going to speak about the potential for international criminal justice under the ICC and through South Africa's domestic avenues. So let me jump straight into topic 1. As I say, I want to start with a disclaimer about the political double standards of international criminal justice, which sadly is on ready display in the Israel-Palestine context. And I think one needs to start with that because it underlines the second part of my talk, which is this critical need, as I say, for a legal, objective approach to what's happening, particularly when considering the question of accountability before the ICC or under universal jurisdiction. As Chris, our host this evening, once presciently pointed out, he said that the political polarization in the world means that South Africa will inevitably find itself pulled in different directions in foreign affairs. And the only way, he said, to keep South Africa committed to its constitutional vision and to act equally and consistently against violations of international law will be for it to adopt the straight and narrow path of the rule of law. Chris repeatedly tells me he can't remember saying that, but I have the quote, and he did write that once before. And I agree with him. Yet, and here's the problem, South Africa, alongside other nations, has not done too well in treading that path. And the disturbing thing is just how obviously the double standards play themselves out. And I need to just give you 3 examples to make my point. The first is the United States. It never signed up to the ICC in 2002, and then it had a very bumpy relationship with the court over the next 2 decades. And when President Trump was in power, he issued a Trumpian-style executive order in 2020, authorizing no less than sanctions and asset freezes and entry bans to be imposed against the prosecutor of the ICC. Why? That was done because the Trump administration was upset that the ICC had begun an investigation into Palestine and the conduct of Israeli nationals in the context of the occupied Palestinian territories. Well, now the United States has changed its position, at least in relation to its old foe, Russia. It sees new value in facilitating the ICC's investigation of Russian war crimes in Ukraine, and it has done so through the agreement to share evidence. So that's as regards the US. Second is the prosecution within the OTP's office itself. This has been pointed out by a number of people. Amnesty International, for instance, has highlighted how in 2020, the Office of the Prosecutor decided not to investigate war crimes by UK forces in Iraq, despite its own finding that these crimes had been committed. And that was followed by a decision in 2021 to deprioritize an investigation into war crimes in Afghanistan by US and Afghan national forces, with the prosecutor Karim Khan citing viability and budget constraints. But just 6 months later, the prosecutor launched his office's largest ever investigation in Ukraine, for which he had sought voluntary financial assistance from member states. And then consider how the Office of the Prosecutor has largely remained silent on the situation in Palestine. And contrast that with the publicity that he and his office have given to the Ukraine situation. It took just 1 day for the prosecutor to make a statement following Russia's invasion of Ukraine, and less than 1 week for him to open a formal investigation. But in the case of Palestine, it's taken the prosecutor's office over a decade to open an investigation. And Chris, again, let me call him out. He has recently written in the Mail and Guardian to highlight that it took the threat to forcibly displace over 1 million people for the ICC prosecutor to eventually find his voice in relation to the conflict in Gaza that's been unfolding. And he spoke for the first time on the 13th of October. And he did that in response to the collective punishment that was unfolding before our eyes and the order that Israel had given to the evacuation of northern Gaza in 24 hours. And on that occasion, he found his voice, but to reiterate Israel's right to self-defense and to state that civilians can't be targeted deliberately. I point all of that out simply to make the obvious point that it's vital for the court's credibility that its messaging does not appear politicized, but its conduct is difficult to read as anything but that. And then third, there's South Africa as an example. South Africa has been a serial ICC flip-flopper. At first, South Africa was instrumental in supporting the court. It was one of its strongest supporters. It was the first African state to pass very progressive legislation implementing the ICC statute into our law. And the crime of apartheid, of course, was included in the Rome Statute because it had taken its meaning directly from apartheid South Africa and our negotiators in Rome. But then under Zuma's administration, we tried to withdraw from the ICC in 2016. That was an embarrassing imbroglio, and that was successfully challenged in South Africa's courts. But the attempt at withdrawal was in response to the al-Bashir saga, which you can all remember, and how badly Zuma's government had been found wanting by our own courts and the ICC when the government failed to arrest Bashir when he attended an AU conference, despite an ICC warrant for his arrest for genocide. So it was largely in response to such criticism that the ANC decided to pass the International Crimes Bill to withdraw from the ICC for a second time in 2016. That languished for many years until December last year, when, if you aren't dizzy enough by now, the ANC government withdrew the withdrawal bill. It said that it was doing so because it was now recommitted to the ICC. Except a problem arose. In the same week that the government withdrew the withdrawal bill, the ICC issued an arrest warrant for President Putin. And Pretoria's claimed neutrality about the war then immediately ran up against two problems. The first is the ICC's arrest warrant, which didn't easily allow any ANC ministers cravenly to continue support for Russia under the veil of non-aligned neutrality. And the second was the looming BRICS conference, as we all recall. Putin had been invited by the South African government to attend in August in Pretoria. And it took litigation by the DA for South Africa to finally, and literally in the halls of the courtroom, to capitulate and accept that they had to endorse the international warrant for his arrest. And we know the result. Putin was forced to zoom in to BRICS from a computer in Moscow rather than a jet. And certain ministers, alongside Julius Malema, fulminated over how badly the ICC was forcing them to treat their good friends. But here we are a few months later, and South Africa's whiplashing intensity has called upon the ICC to arrest Israel's leaders and has referred the Israel situation in Gaza to the ICC for investigation. Now, that's absolutely right. It should have done so. And Naledi Pandor should be, in many respects, applauded for having done so. But it comes on the back of this very difficult embrace of politics and the double standards that unfortunately, sadly, seem to inflict international criminal justice, whether that's by superpowers, whether that's within the OTP itself, or whether it's our own government. And let me finish this introductory first topic. It's that I said it was a disclaimer on my part. I chose the word carefully because I don't think we should allow international criminal justice and its principles to be sullied by politics or by administrations or by prosecutors. I think instead, aware of those dangers, we should disclaim and we should denounce such double standards as having any rightful place in international criminal justice. And we have to redouble our efforts to insist on equality and consistency in the application of its principles, precisely because the values it protects are universal. And that leads me then to my second topic immediately. It underlines the importance of what I'm about to say, which is the critical importance of the international rule of law. The al-Bashir saga demonstrates how an absence of political will or the existence of the wrong kind of political will can result in the subversion of international criminal law. And that's why the rule of law domestically and the international rule of law before the ICC needs to be dispassionately and objectively advanced. South Africa's courts, I stress, not its administration, but its courts, have again shown the way. They did that in relation to al-Bashir, finding that South Africa had violated its international and domestic obligations by not arresting him. And they did so in relation to the Putin arrest warrant. Pretoria's fawning neutrality about the Russian war in Ukraine ran out of legal runway, as I said earlier, in a case that the DA brought in July this year. And we therefore see how critical it is for the international rule of law to be objectively and dispassionately applied, and when it is not applied by political actors, for our courts to step in. And so that then brings me to the third topic, and it's accountability for crimes in Palestine and Israel. And having said what I've just said, I've said it for a reason. We can now speak honestly about South Africa's role and how best it might support justice and accountability in this conflict with consistency. And there are 3 points I'm going to make briefly before closing. The first point is apartheid as a lens. I want to stress there's no justification for Hamas's terrorism and the crimes that were committed on the 7th of October. None. Whatever the right to resistance that Palestinians may have had under international law, in my view, armed resistance must always respect international humanitarian law, and the murdering of civilians and the taking of hostages is simply not a valid exercise of the right to Palestinian self-determination. But having said that, one has to be alive to the conditions that are at least conducive to all of the increasing violence in Palestine-Israel. As Navi pointed out in her address, the UN Secretary General has contended that Hamas's violence and it itself did not originate in a vacuum. It was created against the background of the structural conditions by which the Palestinians have been denied for decades their birthright and to gain control over their own lands and to govern their own lives. And one of the features of the conflict, and where South Africa can play, I think, a meaningful role, is in respect of contextualizing and historicizing the conflict through the lens of apartheid. The escalation over the past 6 weeks has produced a sickening list of international crimes, expanding in degree and kind daily. But those crimes occur in the context of the illegal Israeli occupation of the Palestinian lands that have lasted now for longer than the formal implementation of apartheid in South Africa itself. Palestine's referral before the ICC thus quite correctly asked the court whether the crime of apartheid is being committed. And South Africa's referral just 2 weeks ago on the 16th of November similarly reiterates that the occupation must be considered by the court as a crime of apartheid. So that rightly requires the ICC to ask the legal question, is the crime of apartheid being perpetrated? Is that the context in which this occupation needs to be considered? And in that respect, to my mind, the customary status of the prohibition of apartheid is beyond doubt. It's, in my mind, beyond doubt, and it's shared by all international legal scholars of any standing. In the words of the International Law Commission, there is now widespread agreement that the prohibition of apartheid is a peremptory norm of international law. It's a jus cogens norm. It's the highest order of norms in international law from which there is no derogation permitted and no excuse or justification allowed. And so Israel, like all states, is prohibited from engaging in apartheid. What is apartheid? Well, it constitutes a crime against humanity in international criminal law. It constitutes a grave breach of international humanitarian law. And it is a prohibited practice under international human rights law. There are therefore these three mutually reinforcing norms, which leave little doubt as to the comprehensive and unconditional nature of the prohibition. And that has now been criminalized in the Rome Statute of the International Criminal Court, which provides for the crime of apartheid as a crime against humanity. Prominent voices have been warning for decades that Israel's occupation has increasingly exhibited those characteristics of apartheid. These include two former ambassadors of Israel to South Africa, who in June 2021 said, and I'm quoting, "It's time for the world to recognize that what we saw in South Africa decades ago is happening in the occupied Palestinian territories too." And on February last year, the former Attorney General of Israel, Michael Ben-Yair, said this. He said, "It's with great sadness I must conclude that my country has sunk to such political and moral depths that it is now an apartheid regime. It is time for the international community to recognize this reality as well." In addition to those statements, there's a substantial and growing body of human rights experts and Israeli, Palestinian, and international human rights organizations that have concluded after deep study that Israel has implemented a regime of apartheid. 8 legal opinions that I can count just since 2019 have come to that conclusion, including by Israeli human rights organizations, Yesh Den, as well as B'Tselem, Human Rights Watch, Amnesty International. And in addition to those reports, it's notable, again, drawing the South African parallel, that in South Africa itself, the South African Human Sciences Research Council released a report already in 2009 that Israel was practicing colonialism and apartheid in the occupied Palestinian territories, a report that Professor Dugard and I worked on together with a number of other experts, a lengthy period of study over more than 6 months that came to that conclusion. And so, yeah, South Africa is able to rightly play an important role. It can identify the practices in Israel as apartheid because it recognizes them as practices that occurred here. And it can call for a legal denunciation of those practices by the ICC. So the South African experience shows that such legal calling out and the ICC's guidance on the step to achieve an end to Israel's policies and practices are critically necessary to confront the true nature of the occupation. It's that denunciation, if I can quote one of our panelists, Professor Dugard, that helped end apartheid in South Africa. This is what he says. He says, like white South Africans under apartheid, the people of Israel will become a pariah people, tolerated but not respected, increasingly isolated from the world. Apartheid, said John, delegitimized white rule South Africa. It has already delegitimized the occupation of Palestine, he said. So that leads to the second point in closing, and that's that states have to prosecute. They have to take accountability and ensure accountability for those who perpetrate these types of crimes. And already in Navi's report that was issued on behalf of the Commission of Inquiry in 2022, it was recommended that states members of the UN have that obligation, including to investigate and prosecute persons suspected of committing or aiding the commission of crimes under international law in occupied Palestinian territory. And the most recent special rapporteur on the situation of human rights abuses in the Palestinian territories, Ms. Francesca Albanese, has similarly recommended that all states have a duty to pursue accountability for perpetrators through both the ICC, through its ongoing investigations, as well as through universal jurisdiction universal jurisdiction mechanisms. South Africa is a member. So South Africa has an obligation as a state's party to the ICC to assist, and it has done that by referring most recently the situation to the court, and it has done so under Article 14 of the Rome Statute. But it can go further. It can assist the court by providing information to the court, and it can also comply with its obligation under complementarity to pursue its own investigations and to gather information in doing so. That obligation is underpinned or aided by 3 statutes. I'll draw very brief attention to them. The first is the implementation of our Rome Statute Act. South Africa has domesticated the ICC statute, and it has the power to exercise jurisdiction under that statute over international crimes committed anywhere in the world, including obviously in Palestine or in Israel. Second statute is the Geneva Conventions Act of 2012. It aims to incorporate international humanitarian law directly into the South African domestic legal system. And it has a very broad jurisdiction which allows for any person, including those who have committed an offense even outside the Republic, to be prosecuted in South Africa for grave breaches. And then third, and particularly enticing for some consideration, is that South Africa has passed the Protection Against Terrorist and Related Activities Act of 2004. The Constitutional Court, in a case called Oka, has explained that the purpose of that act is to create an offense of terrorism, that it gives effect to international instruments, to extend South Africa's court's jurisdiction over those offenses wherever they are committed, and to fulfill our general duty to combat terrorism wherever it may be perpetrated. The definition of terrorism is broad. It says that terrorist activity covers any acts committed in or outside South Africa which involves the systematic, repeated, or arbitrary use of violence, which includes causing serious bodily injury or the killing of any persons or persons, and which causes the destruction of or substantial damage to any property or to natural resources or the environmental or cultural heritage of a place, and which is designed to disrupt seriously any essential service. Just read those or think about those paragraphs again, and you can immediately see the analog for what's taking place right now in Israel, Palestine. The activity must be committed for the purpose of the advancement of an individual or collective political, religious, ideological, or philosophical motive. And so there too, you can see the analog. Already we have a very pertinent example in South Africa in the Constitutional Court's decision in Oka. In Oka, Mr. Oka had been convicted by a South African court of planning and financing various bombings that occurred not in South Africa, but in Nigeria. And in the course of finding that, the court not only stressed the importance of South Africa acting on an international stage against these types of international terrorist acts, it also highlighted that there is a potential defense, and that the defense is in Section 1.4 of the Act, which exempts acts of terrorism where they are in the exercise or the furtherance of a legitimate right to self-determination. But here's the critical rider, that any act must be taken in accordance with the principles of international law, especially international humanitarian law. And the Constitutional Court in Oka has stressed that any exemption will be strictly scrutinized. And let me just read for you the court's words by Justice Cameron, which could have been written for what we are now witnessing before our eyes, when he denied Mr. Oka the right to claim that he was acting in furtherance of self-determination. He said this: One of the cornerstones of international humanitarian law is the obligation to distinguish between combatants and civilians and between military objectives and civilian objects. Military action, said Justice Cameron, may not directly target civilians, nor may it be taken with indifference to the effects on the civilian population. So we have OCA, and we have it as a very powerful precedent. So let me finish and conclude in around 1 minute. The point I've been trying to stress is that we're witnessing grave crimes being committed before our eyes. They naturally demand a response. They allow us as South Africans an opportunity to draw attention to apartheid as an animating and illustrative context for understanding the violence and for framing the legal issues that are at stake. And South Africa now has an opportunity to apply multiple international standards within its statutory armory to seek accountability. Yet international criminal law requires more, perhaps now than ever, if its legitimacy is to be restored. It requires an objective application. That means that our past fealty to our friendship with Russia or to Hamas or to Sudan or wherever is no excuse not to call out evil whenever it's happening. We claim to be a country based on the rule of law. So when a state acts in a manner that debases the very foundation of our laws, then we must denounce that, or the rule of law will be diminished by our complicity alongside such actors. And our international obligations are not loosened by or relative to our political friendships. When Putin is wanted by the ICC, we have a duty to arrest him for alleged war crimes. The same equal commitment to international criminal justice should be demonstrated by South Africa in responding to allegations that Hamas leaders have committed such crimes. They too deserve to face justice with South Africa's help. And in the same way, Israeli leaders and soldiers should be accountable for their crimes. Because when we show that consistency, we strengthen the legitimacy of international justice and our own domestic commitment to the rule of law. And when we act in that objective and consistent way, then we can rightly claim the space to berate superpowers of the world for their hypocritical and self-serving commitment to international justice. And then we can righteously demand reform of the Security Council for its abuse of its veto power. And we can then, by international criminal justice, insist that there's no cause so great as to justify the death of a child, no matter whether that child is Palestinian, Ukrainian, Israeli, Sudanese, or whatever. Thank you very much, Chris.
Thanks, Prof. du Plessis, for also bringing this both to the framing of apartheid and also to bring it quite concretely to the question of South Africa's role. So I thought I might go back to you, Dr. Pillay, just to pick up some of the threads that Max laid out for us. In particular, what you think the framing of apartheid does to the conversation at a diplomatic level. So to what extent does that framing assist? What types of resources does it open up? Because it's true, absolutely, that the UN was instrumental to the end of the apartheid, but it's also true it took a very long time. So is it a different UN that faces apartheid this time? Is it the same UN? Can you see different leverages and levers of power that are opened up by the framing of apartheid?
Thank you, Chris, and thank you, Max, for fitting in the apartheid into this dialogue. I should say, you know, very many organizations, important organizations like Amnesty International, Human Rights Watch, many others have approached our commission to make apartheid as the root cause. And we thought otherwise and felt the overall umbrella cause is the occupation. Apartheid fits under there. You end the occupation, you end the practice of apartheid. However, I mean, we're not on, you know, we complement one another, all the various arguments. So I want to make that clear because there has been much disappointment by people working very, very hard in bringing up the apartheid, which I see as a strategy, actually a strategy to mobilize and a ground that is not as easily dismissible by member states. You focus on that now, Chris, because the United Nations Charter prohibits racism. And yet, during our struggle, it was Ronald Reagan, US President, and Margaret Thatcher, the UK Prime Minister, who used the veto to stop sanctions against apartheid South Africa. And of course, years later, when I was High Commissioner for Human Rights, I had the opportunity, when addressing the Security Council, to point out that they had used the veto selectively against a founding principle of the United Nations, which is an intolerance for racism. And so therefore, I think that where you're going with your question, that there would be ready support by member states on the strategy or on the prong of apartheid. We will cover that in our commission, but we felt we need to focus on ending occupation. That was what we determined. We will be working with many others in getting the focus on apartheid. You know, as you mentioned, I was a judge on the International Criminal Court, and it's the first international instrument that has included apartheid as a crime against humanity, and so on. So we now have the means to address this both under criminal law as well as the whole packed framework of international humanitarian law, human rights law, and the Geneva Conventions. So I think I agree with Max that South Africa is in a position to play a role. I know they often ask, why is it for them? Why is it their burden to pursue the Durban Declaration on racism? Well, the world looks to us to take the lead on this, to provide the model of leadership, and we should. So we are in ongoing discussions with many people, with many academics. We've had the benefit of all points of view on this. We're not dropping it, the apartheid strategy, I would say.
Thank you, Dr. Pillay. And to you, Professor Dugard, a similar question. So you wrote a book called Confronting Apartheid, and you spent much of your career working against the system of apartheid through international law. What do you think that framing does from an international legal perspective? What types of avenues does it open up, both diplomatically, but specifically in questions of international law? Oh, you're muted, Prof. You're muted.
I'm not quite sure what you mean by that. You want me to comment on the opportunities that the illegality of apartheid presents for the conflict in Palestine?
So focusing on this from the perspective of apartheid as a crime, but also apartheid as a violation of August Kogan's norm, what types of state action is opened up by that? So, for example, under the Apartheid Convention, under the question of sanctions, what is the possibility for illegal action? What's the legal imagination? How is it expanded by framing this as apartheid?
Well, on the subject of apartheid and the Apartheid Convention, what is the position of South Africa today in relation to the Apartheid Convention? Several years ago, I was told that it was about to ratify the Apartheid Convention, but as I understand it, it has not yet done so. Is that correct?
It is in the final stages of doing so. So it's passed through Parliament and it is in the process of ratification, the drafting of necessary legislation. So soon to the list of acts that Max spoke about, we can add an Apartheid Act, domesticating apartheid, the convention in South Africa. But that's in the wings. It's yet to happen. Hopefully 2024, we hope there will be a convention, an implementing act introduced.
Well, that will be very important, particularly as far as South African national law, domestic law is concerned, because it will open up an opportunity for lawyers to litigate on this subject. As far as international law is concerned, I think it's very important that the issue of apartheid has now received prominence in respect of the advisory opinion, because it is quite clear that Israel's policies and practices have been portrayed as a system of apartheid. I think it's worse than apartheid in South Africa, and it does present the International Court of Justice with an opportunity to pronounce on the subject of apartheid. And I think that will have very serious implications for Israel. Because once it is found that Israel is practicing the policy of apartheid, there can be no justification for the failure of the United Nations, the General Assembly, and the Security Council to impose economic sanctions and other sanctions on Israel. So I do think it's a very important tool, as it were, to encourage the United Nations to take strong action against Israel.
Thanks. So if I can just a follow-up question. So you mentioned the 1971 advisory opinion on Southwest Africa. Of course, there's a more infamous decision on Southwest Africa, which was the 1966 decision that dismissed the claims in the case of Liberia and Ethiopia. So the International Court of Justice has been patchy on the question of apartheid, and I wondered whether you think which of the courts will we get this time around? There's obviously been a recent set of elections. Are you confident that the court that we have will not be the court of 66, but rather the court of 71?
I think the decision of 1966 weighs heavily upon the memory of the International Court of Justice, because you will recall that after the 1966 decision, the International Court of Justice virtually went out of business because states boycotted the International Court of Justice, refused to refer cases to it. And it was only the decision of the court in the dispute between the United States and Nicaragua in the mid-1980s that gave the court some legitimacy. And I think the court will be mindful of that experience. So I don't think one can expect a decision of that kind, of the 1966 decision. I think it's more likely to be influenced by the 1971 advisory opinion. And quite frankly, the law is very clear on the issues that will be brought before the court in the advisory opinion. The only question is whether the court might be influenced by some of the preliminary objections raised by the United States and the United Kingdom in the context of the present conflict in Gaza.
Thanks, Prof. Dugard. So to you, Prof. du Plessis, so a similar question. So if one reads the General Assembly resolutions in the immediate aftermath of 1966, one has a bit of deja vu, because the claims that were made about the ICJ in 1966, that this was a tool of Western imperialism, that it was biased, that it was political, are the very same claims that have been made about the International Criminal Court. And obviously those claims have been litigated in journal articles and across for a number of years. But this really does seem like a tipping point in a sense for the ICC, because the prosecutor really would have to try very hard not to pursue at least some form of investigation and prosecution in respect of this case. And yet the prosecutor seems to be doing just that. You mentioned not only the slow response of the prosecutor, but the reasons for refusing to investigate the case, the situation in Iraq, for example, was because the prosecutor put tremendous faith in the judicial system of the UK. Even though 17,000 cases had been investigated, not one had been prosecuted, the prosecutor's office said that was not quite unwilling. I'm not sure what is unwilling, if that's not unwilling. And in the case of Afghanistan, the reason that was given by this very same prosecutor was that the acts of ISIS were somehow worse than the hundreds of thousands of civilians that have been killed by US and NATO forces in Afghanistan since 2003, when the court first had jurisdiction. And here we see in this case as well the language of this is a question of us versus ISIS. So we've seen already, in some senses, the groundwork being laid for either not pursuing a case or for pursuing a case that focuses just on October 7th and doesn't see the broader context. In the event that that's where, so two questions, I guess. One is what can we do and what should South Africa do to prevent that? What are the levers, without interfering with the independence of the prosecutor? What are the levers of pressure, legal and otherwise, that can be applied? And what happens if those don't work? Is the legitimacy runway for the ICC running out? Is this the final test? Yeah, go ahead.
So I'll answer those questions in a moment, but just to pick up on where you were going with John around the ICJ decision, I do think, and this is for me at least, a positive sign of things, which when you read a book such as that by Philippe Sands, The Last Colony and others, and you think about the Chagos Island decision, the ICJ seems to at least have internalized that there is a colonial practice that must come to an end. It had to come to an end in Mauritius, and it recognized that self-determination has become one of those fundamental norms that needs to be properly respected. And so my sense is that we won't have a 66 decision. We've moved way beyond that, and I certainly hope that the court will tackle the issue properly within the context of what seems to be a much more accepted understanding of self-determination and its role in the international legal firmament. But to the ICC question, it is, and of course I'm going to be slightly careful here because I'm involved in the matter, but it is particularly important that the prosecution not be allowed to dither, not only for its own sake, its legitimacy is at stake, but also because I think states are frustrated with the court. And not just states generally, but particularly states that have an interest in what's happened in Palestine. And that's where I do see great value in the South African referral, because I think the South African referral is a difficult one for the prosecutor to ignore. It comes at a time by a state that has got the support of the Global South, and it comes from a powerful state that says what is happening here needs to be seen beyond 7 October. It has to be seen within a bigger picture, and the context for the court is going to be difficult for it to ignore. So I think South Africa's referral is very helpful there. If the prosecutor doesn't do anything, Chris, I think, there are multiple potential strategies. And the one, of course, would be to call the prosecutor out at an Assembly of States Parties type of event and to say that there's a crisis within the court and something needs to be done about it. The other is to potentially think of a review of the prosecutor's failure to take action. The third option is for there to be a denunciation of the prosecutor as an official within the court. There are different ways to do it. I wouldn't want to say more than that, but I do think that this is a critical moment for the court and that the prosecutor is going to have to do more than has been done.
Thanks, Matt. I'm not sure if we've lost Dr. Pillay. So let me turn to you, Prof. Dugard. This is obviously a very, and I'm sure you would have seen. Oh, there we go, Dr. Pillay.
Very sorry, because I had to step out just for a second. Did you address the question to me?
I'll address. I was directing it to your professor, but I'll redirect it to you if that's okay. So you mentioned the hostile reception that you've received at the UN, and I think this is a very fraught time. And you've seen this on college campuses across the US as well. It is a very divided time. In your time at the United Nations, have you experienced anything like this level of, I guess, bifurcation on a particular question? And if not, how do you see, what is your role in trying to make sure that everyone who has a sense that their side's not being heard is heard and is assuaged and really has faith in the outcome of your reports, which obviously is very important to their legitimacy and to the impact?
It's good you mentioned this. This current conflict has really created huge divisions, especially on campuses. I've not only been on campuses here in the US, but also in Canada. And I've addressed them. The panel addressed people, and individuals came up to us to say they're afraid to talk. So I'm totally amazed about how quickly people are taking sides in the matter. I hope that I've made clear to everyone that this is an independent panel. We follow the evidence, we follow the law, and that's what they should be doing. On the other hand, inside the UN, there have always been selective application of UN principles. There have been double standards. So very often I respect the courageous role that the South Africans play, and are expected to play, for instance, at the Security Council and so on, because they are reacting to these double standards. And that is very much now in effect when it comes to Israel. As we all know, states have made it very clear that they have special relationships with Israel, and so they will never take up a position, not even against Israel, but that they will not take up a position, any position that is critical of Israel. In the Human Rights Council, there is an agenda item, item 7, I think, specifically on Israel. And from the time I became High Commissioner there, I kept hearing all around that the Human Rights Council has become a place just to badger Israel. They only focus on Israel and they're not focusing on other countries. And I explained that 2 countries were on the agenda of the old Human Rights Commission, which was then reformed into the current Human Rights Council. And of those 2 items, one was South Africa under apartheid and Israel-Palestine under occupation. Apartheid ended, so we came off the agenda. This item remains. So that's the reason. There's just no way they could take it off the agenda until the occupation ends. So it's not targeting any particular country. But do you know, each time that item comes up, the whole of Europe refuses to even participate. They refuse to even attend the discussions. So these are the polarized positions you have there. I also notice huge divisions between developed countries and developing countries. When I would chair, for instance, a session in the sidelines of the Human Rights Council on economic and social issues, you'll see a very significant absence of developed countries, much more developed countries seated there. And similarly, on political and civil rights issues, the position would be reversed. Very poor attendance by developed countries, a massive attendance by European countries. So this kind of selectivity will go on and influence even the establishment of commissions and how they're going to react, how the votes go. I mentioned that it took us just 2 days from the October 7th attack to issue a public statement condemning the attack, asking for a cessation of hostilities, and asking for release of the hostages, 3 things. But the Security Council held discussions throughout those days while I was in the corridors. No decision was taken because of this constant conflict about exercising the veto. So no resolution from the Security Council on such a serious matter, which goes to the heart of why we established the United Nations in the first place and why the Security Council has this supreme power of peace and security, to maintain peace and security everywhere. Then it took the General Assembly to pass a resolution 12 days after the conflict started in Israel-Palestine, and they could not agree on the word cessation or ceasefire. Nobody wanted that word. And yet the people on the street, that was their first call. Let the killings stop. The killings must stop. Humanitarian aid must go in. So the language they settled on instead of ceasefire is a humanitarian pause. So that's what we have now from the General Assembly, to get humanitarian pause in. So, you know, I try to keep away from all the political influences, because I come as a judge, I'm sitting here as an independent commissioner. I like to stay with international law, and as our 2 colleagues have set out, there has been great advances in international law, and I see great scope for us to call for the full implementation of international law. As Max said, it's all these 3 major bodies of law are applicable now in the Palestinian situation. So with regard to the prosecutor, well, that would be difficult for me to comment. He is independent, but I share some of the anxieties we have on over statements he has made and over his inaction. But I must, to be fair to them, I must say that the deputy prosecutor, who is in charge of Palestine, I think, did write to us and make a formal request for sharing of information. So to me, that is an indication that they have begun to work on investigating the situation in Palestine. Thank you.
Thank you very much, Dr. Pillay. Professor Dugard, so one of the things that Dr. Pillay mentioned was the logjam at the Security Council. And obviously this was something that happened during apartheid as well. And opposition to apartheid often took place, not just in the General Assembly, but through things like the Apartheid Convention. And the Apartheid Convention itself had particular mechanisms for its implementation. So the Group of Three, I think it was called, and various other committees were established in relation to apartheid in South Africa. Do you think the South African government, once it's implemented the convention, should take the lead in re-establishing those mechanisms under the Apartheid Convention for the purposes of applying them to occupied territories?
You know, I think that we've gone beyond the Apartheid Convention, that the Rome Statute is the dominant international instrument today, and the Rome Statute does criminalize apartheid. And I think that we should look more to the Rome Statute rather than the Apartheid Convention. I think the Apartheid Convention suffers from the fact that it was not implemented at all during the period of South African apartheid. It was referred to once in a South African decision. It perhaps had some influence in that case. But generally, the Apartheid Convention has not been implemented. And I think one really needs to look to the Rome Statute and the fact that apartheid is a crime against humanity under that treaty rather than to the Apartheid Convention. That may not be the answer that you expected, but I do think that the Apartheid Convention is not a dead letter, but that it's more of historical interest than the Rome Statute.
So, I mean, and I think thinking about the Rome Statute specifically, so a question coming to you, Prof. du Plessis. So you mentioned and rightly, I think, applauded the referral by South Africa, which in some sense is an analog to the referral, I think, of 43 odd states of Ukraine, of the situation in Ukraine. But there's a very big difference, right? Which is that the referral by the Western group of states in respect of Ukraine was backed up with contributions and promises of investigative support, and in-kind contributions, and for the first time cooperation from the American government to some extent, and evidence collection, and so on and so forth. To date, as far as I know, the referral from South Africa is just that. And obviously, the ability of a state to assist the court is dependent on the capacity and, quite frankly, the economic standing of that particular state. So in the absence of those resources, what role do you think civil society can play, both in terms of supporting and capacitating the investigations of the ICC, and failing that, in supporting and capacitating domestic investigations, as they have in other cases? And I ask this specifically knowing that this is something you've been involved in South Africa in terms of working with organizations, so perhaps you can speak to that.
So I think they can assist in multiple ways. The first is that they, through their own resources, can try and assist by compiling dossiers and gathering information about crimes which may have been committed as best they can to ensure that at least there's a potential for the use of universal jurisdiction. There is a difficulty that they will face, which is that nobody can get into Gaza, nobody can get out of Gaza, and it's particularly difficult to gather that evidence. And without the International Criminal Court's ability to do so and to insist on being able to gather that evidence. So they should be able to, as civil society, demand that the prosecutor does more, and that states and the Assembly of States parties here again can play an important role encourage there to be, certainly in relation to this type of event, which is at the level of atrocity, that there is the ability for there to be a gathering of information and evidence, which is going to be facilitating the investigation. So that's the one thing that they can do. Secondly, it's on the question of budget. When one looks at how the budget is allocated in the ICC, there's lots to be worried about. And states should be insisting that when the prosecutor says, well, I don't have enough resources to tackle Palestine because it's too much for us, we don't have the money, one has to call out the fact that, well, you got the money in relation to other places because, as you highlight, Chris, there were willing and able states bringing not just a referral, but money behind it. Well, then that has to be something that is leveled, either by virtue of a proper discussion of how the budget is being unfortunately skewed in the context of important situations, and that budget needs to be remedied. The debates can be had, and that civil society can insist on. And then in another way, I think you can find that the important roles here for civil society and in concert with states like South Africa could play. I take your point, and John's right, that the Rome Statute is a better place to think about apartheid as a crime being investigated and thought about. But I do think that there's a healthy role for South Africa, if it is going to be signing up to the Apartheid Convention, to play. It can insist that the Committee of the Three is invigorated, and that it is as part of the Committee of the Three demanding that states are appointed or states appoint committee members to concern themselves with the crime of apartheid under the Apartheid Convention. And that helps, I think, also symbolically for South Africa to be able to quite rightly insist that apartheid is a serious enough issue for it, that it not only within the Rome Statutes framework, but also under the Apartheid Convention is demanding that these types of activities are considered properly and contextually.
Thank you very much, Prof. du Plessis. Just finally coming back to you, Dr. Pillay, can you give us a sense of what the next couple of months will involve? How do you intend to pursue your report? What type of diplomatic efforts are going to be undertaken? What role do you think states have to play in supporting those efforts and civil society? What kind of partnerships do you envisage?
Well, I'm noticing there have been many demands, both from inside Israel and the world, to the United Nations. Why aren't you investigating what's ongoing now? And some of the responses have been that our commission is investigating. And of course, firstly, let me say, with being required to play such a huge role and not having resources is obviously a handicap. But why we are able to conduct immediate investigations is the huge support and flowing of information from civil society. So a great deal of cooperation from civil society and academics, various writers, and so on. So as I said earlier, our immediate involvement now will be in collecting, gathering, and pursuing the angle of investigation, working closely with the ICC, because we are able to do that. So we've made a call for submissions, and we're endeavoring to meet with Israeli hostages and other nationalities who had been involved in the hostage taking, that we are endeavoring to meet with them where they are, for instance, in Egypt. So some efforts are being made immediately. And as I said, we've stopped our planned reporting in order to, because we said that this is such a crisis, it will influence the situation seriously and deeply. We cannot ignore it. So this is what we're focusing on, and also working on producing a full report for June next year. But we're not in the business of just producing reports. We're very actively engaging with states. We're meeting with groups of states, with the European Union human rights concerns as well, to ask questions, to ask for cooperation. So that's the level we are working on. And of course, I'm in close touch with UN representatives as well, the various agencies who are seriously handicapped in delivering on their mandates of humanitarian aid. So these are priorities in my mind that we have to work together on that. So my commission is then jumping into this and doing whatever we can.
Thank you very much, Dr. Pillay. So just to zoom out as we come to an end and to go to some of the questions in the Q&A, I thought I might put it to you, Professor Dugard. What do you think this all means for the peace process? Is the peace process well and truly over? Is the two-state solution well and truly dead? Do you think this will delay, accelerate, postpone indefinitely the ongoing negotiations? Does this only end in the courtroom?
Well, that's a big question, but one must bear in mind that there has been no peace process for the past few years. Israel has stopped negotiations. It argues that it does not have a negotiating partner in the Palestinian Authority, and so there are no negotiations. And the United States, under the Biden administration, seems to be quite happy with this arrangement of no negotiations. It's only since the conflict in Gaza started that the Biden administration became involved. Obviously, I think there's a need for a peace process, for negotiations. I think the first thing that one has to accept is that the United States should not be an honest broker, because it is neither honest nor a broker, and that one have to find some other negotiating partner. The United Nations could appoint skilled negotiators from neutral states or states which are acceptable to both parties. I do think there's a need for negotiations to assist the parties in deciding whether how the situation is to be resolved. I don't want to get into the issue of a single state or two-state solution. All I would like to say is that I think the present conflict in Gaza has made it virtually impossible to contemplate a situation which the two communities will be able to cooperate in as a single state. The brutality of the Israeli assault on Gaza has really hardened attitudes in the Palestinian community, I fear, and also in the Israeli community as a result of the attack on the 7th of October. So I think it's very difficult to predict what type of constitutional arrangement will be made, but I do think that there is a need for talks and negotiations conducted by an honest broker, and that excludes the United States.
Thanks very much.
And if I may just add something,
please go ahead.
Yeah, it really puzzles me, the reaction of other states. For instance, Europe, the opposition to this commission, for instance, is that any seeking of an ICJ opinion will be an obstacle to the peace process. And so it's almost like what they preferred is that the status quo remain, meaning no movement except more and more land exploitation. I know civil society says land grab, dislocation of people. That is going on fast and furiously, but otherwise they want the status quo to remain. That was stated to me by some representatives. So rather than helping with the peace process, they just want things to remain as they are with no movement. So that's a dismal picture there. Thank you.
And just to follow up on that, do you think that there's a role for South Africa as a mediator in this particular conflict, given our history, given our ability to deal with an intractable, seemingly intractable conflict?
There's a role for South Africa, not only because of our history, but because we're a member of the United Nations. So that's a responsibility of all the members of the United Nations. They should not be operating on the basis of business as usual or establishing special relationships with Israel, for instance, and therefore not wishing to, as they say, upset the apple cart. You know, as I said, I was very surprised about the number of states who objected just to this commission of inquiry. Why would they do that? So I think a strong call should be made by civil society to all their governments to play their role. Now's the time. They cannot continue with business as usual and following their old traditional ways of voting. So not only South Africa, other countries should exercise all the powers and opportunities they have to address this matter as a situation of urgency, because people are being killed while we are speaking.
So I'd hope to end on a more positive note, but unfortunately, I think that's probably the most honest place to end. I just want to say a huge thank you to our three esteemed, both professors, practitioners, judges, commissioners. You've all used these different roles in very powerful ways and are an inspiration, I'm sure, to both your alma mater or your former employer, and also to our students as well. So I want to say thank you. I didn't get a chance to study under any of you, although I have, except for Max. I think I have studied. I've learned a lot tonight, perhaps more than I learned under Max. But nonetheless, I'm fully enriched for the conversation, and I thank you very much for your time and attendance. And I'm going to hand over to Dr. Hicks, who's just going to close our proceedings. Thanks, Janine.
Thanks, Christopher. And really just to reiterate, deep felt thanks to our three panelists for your inputs and drawing on the very specific positions that you occupy and the work that you've done in this regard. We really appreciate your insightful comments. Thanks to my colleague Christopher for his wonderful facilitation and questioning of our panelists. He did manage to weave in the issues that were captured in the Q&A chat, so many thanks to that. And thanks then to Hazel Lange and our publicity team from the School of Law, and to our acting dean, Prof. Warren Friedman, for enabling the School of Law to host this very important webinar. In the Q&A, and I think on the webinar chat, Hazel has placed the YouTube link for those who'd like to share the discussion with colleagues and friends. And as indicated, we will be back. We will send out a communique to all of those who RSVP'd for this webinar, inviting you to join us to our probably end of January, Christopher, webinar, preceding the ICJ hearings that our colleagues made reference to. So from dark load shedding, where I am, many thanks to everyone for joining us, and we wish you all a good evening. Bye.
Thank you.
Thank you.
Thank you very much.